5 seconds to go. Start. At the outset, the learned senior counsel for respondent number 1, in an attempt to sustain the acquisition, strenuously contended with regard to eminent domain of the state in the matter of acquisition of land for public purpose, and relied upon the case in Coffee Board Karnataka, Bangalore versus Commissioner of Commercial Taxes Karnataka and others, 1988 3 SCC 263. To be fair to him, though, we have noted, we are however clear on that aspect that the state has the power. But the position of law is also well established that in view of Articles 300A and 31A of the Constitution, the owner of land can be divested only in accordance with law after appropriately compensating if such land is required by the state for public purpose. Since such power of eminent domain is not in dispute, we need not advert to the decision referred in detail. In the normal circumstance, the process for acquisition would commence with the notification under Section 4, after which the procedure under Section 5A is complied. The declaration under Section 6 is thereafter made when the requirement of the land for public purpose is confirmed. Thereafter, the process for determining the compensation and taking possession through Section 11 and Section 16 of Act 1894 is contemplated, which is undertaken after issue of notice under Section 9 of Act 1894. Insofar as the said process, in order to protect the interest of the land loser to be compensated within a time frame, failing which to give him benefit of his own land, Section 11A was inserted by Act 68 of 1984 with effect from 24 September 1984. The said provision leaves no ambiguity whatsoever that if the award is not made within the period of 2 years from the date of publication of the declaration under Section 6 of Act 1894, the entire proceedings will stand lapsed. The only option for the acquiring authority, if the land is still required for the public purpose, is to notify afresh from the stage of issuing notification under Section 4 of Act 1894. The computation of 2 years would, however, exclude the period if the process was stayed by an order of the court. This aspect has been clarified by this court in Yusuf Bhai versus State of Gujarat and another 1991 4 SCC 531, placed for our consideration by the learned senior counsel for the appellant. So far, so good. The question, however, is as to whether the rigor of Section 11A of Act 1894 will apply when the appropriate government exercises its special power in cases of urgency which does not contemplate the same procedure as in the normal acquisition process noted above. In this regard, also this court in Yusuf Bhai Supra has held Section 11A is applicable to acquisition under Section 17, though without detailed discussion. From the provision of Section 17 reproduced supra, it is seen that the acquiring authority will be entitled to take possession without taking recourse to the procedure, which is otherwise provided under Section 16 of Act 1894, wherein it contemplates the passing of an award before taking possession. Stop.